Yes, Mr.
My lords, my lady, I was seeking to remind my Lady Hale and my Lord Brown of the Wilkinson decision, which concerned a mental patient who was refusing psychotic treatment. Wilkinson, I don't want my lords to go to it. It's
Yes.
a volume. It's a tab 401, volume 40, at paragraphs 56 and 60 of Lady Justice Hale, she then was. And the interesting point was that the claim was brought as a judicial review, and the court held on an interlocutory appeal that cross-examination would be appropriate because the claim could have been brought as a tort claim for assault. The interesting point for present purposes on the causation element that is in the tort, that the requirement of directness, was in my lady's observations as to the RMO's potential liability, because he was ordering or carrying out the treatment as against the appointed second doctor's liability, because he had a different role. And my lady observed that a difficult causation question might arise, and she wasn't, if I venture to suggest, talking about whether or not the claimant would have been battered anyway. The causation question related to who was responsible for the battery. That's the causation element in the tort. That doesn't arise here because the Secretary of State says it's her own decision which is an issue. That's at Secretary of State case 7.18. The Secretary of State is responsible, and the contrary argument was tried in another case and summarily rejected by Lord Justice Brooke, and the reference for that is D and Home Office, volume 14, tab 141, page 1019D. So there, the Secretary of State tried to argue that the Home Office weren't liable because they weren't turning the key in the lock and were merely authorising the detention by a contractor who had no duty, who had no scope other than to obey that order. So, my lords, my lady, I now want to move to the cases upon which we rely in our printed case at 65 to 76 for the proposition that the causation test as applied by the court and as urged upon you by Mr. Beloff has no place in the tort of false imprisonment. And the first case I'd like to take you to very quickly for obvious reasons is the Christian Machinsky case, which is at volume 4, tab 41. The facts are at the facts are at 575 to 578 in very short order. It's obviously so well known. So Machinsky was arrested at a warehouse in Liverpool. Christie and the other officers suspected him of having stolen or feloniously having received a bale of cloth in Leicester, but they didn't give this as a ground of arrest. Instead, they charged him on account of unlawful possession under a local statute, the Liverpool Corporation Act, but that act gave them, in the circumstances, because they knew of his address in Southport, no power of arrest without warrant. The classic passage is, of course, from Viscount Simon, and you have that at 587. I've lost my balance. In the middle of the page, it's described as a classic passage by Lord Justice Clarke in the Taylor case, in 2004. And then, for our purposes, very quickly over the page at 588H, 5 lines up from the bottom, I entertain no doubt that in the present case the appellants are not exonerated from liability for false imprisonment by satisfying the judge that they had a reasonable suspicion that the respondent had been guilty of theft or of receiving stolen goods, knowing that they had been stolen, when they never told the respondent that this was the ground of arrest. So, no causation. And the force of this is not diminished by the fact that in Sardi, the House of Lords concluded, or at least appeared to be of the view, that the giving of bad reasons didn't vitiate a detention in the context of immigration powers.
The giving of?
Inaccurate reasons. I'm going to come on to Sardi, because it's a case which Mr. Beloff relies upon. And you've also, I've read out to you, my lords, my lady, the passage from Lord Simmons at page 595,
Yes.
the top of the page. I've read that out to you. The next case I wanted to take you to, in support of the proposition that the tort of false imprisonment recognises no causation defence, is the case of Kuchenmeister, which is at volume 4, same volume, tab 45. If my lords will just quickly look at the first column on the page, that will give you the relevant statutory provision. It was the Aliens Order, Article 1. Subject to the provisions of the order, an alien shall not land except with leave. And then Article 2, subject to paragraph 2, leave to land shall not be required. Then B, in the case of an alien who lands from an aircraft at an approved port for the purpose only of embarking in an aircraft at the same port, and remains, these are the critical words, throughout the period between his landing and embarkation, within such premises or limits as may be approved for the purpose by an immigration officer. And what happened was that the immigration officers fell foul of that article. They imposed limits which were beyond them. They frustrated the purpose of that section because he couldn't catch his onward flight. He was trying to get to Dublin. Article 2.2, notwithstanding anything in paragraph 1, an immigration officer may at any time refuse leave. That's the hypothesis. That's what's relevant to the causation issue. The immigration officer could have refused leave, and that would have triggered a power of detention. If you go to the bottom of the right-hand column, you have Article 8.4, alien to whom leave to land is refused may be detained. So you didn't need leave if you were a transit passenger remaining in approved premises for the purposes of onward flight. You didn't need leave if you were doing that. An immigration officer could have refused leave at any time, and if he did that, he could have exercised a power of detention. The relevant passage is at, first of all, 509. The bottom, the final paragraph on the page, very distinguished representation, my lords, my lady will see. Mr. Scarman concedes that the defendants could have provided themselves with a justification for the plaintiff's detention because the powers conferred upon the immigration authorities by Article 2.2 could have been utilised in any period during the evening with which we are concerned. It would have been open to the second defendant to refuse the plaintiff leave to land, even though he had in fact landed lawfully under the provisions of 2.1b, and then that would trigger the detention power. Mr. Justice Barry held that the immigration officers had not exercised their powers under 2.1b correctly, see 5.110, the facing page, because they had done so as to frustrate the purpose for which the paragraph was included in the order. And then at 5.12, this is the critical passage for our purposes, 5 lines down. His liberty was restricted to a greater degree than the immigration authorities were entitled to restrict it under Article 2.1b. The fact that they might have restricted his liberty by employing the powers conferred upon them by other articles of the order seems to me to be immaterial. It is no answer when a man says, I have been unlawfully arrested without warrant, to say, well, had I, the person making the arrest, taken the trouble to go and ask for a warrant, I would undoubtedly have got it. That was the position in Intick and Carrington, of course. That would be no answer to a claim for unlawful arrest. Similarly here, although the second defendant and his colleagues could have detained the plaintiff by refusing leave to lend, that doesn't entitle them to detain him on the grounds on which they did. The next case I'd like to take...
Mr. Hussain, could I just ask you this as a matter of principle? How much assistance is it in this appeal to refer us to decisions of judges at first instance?
My Lord, I take your point. I was referring to this case as an example.
As an illustration, really.
As an illustration of an old case in the immigration context where an action in trespass is brought and a causation defence is flatly rejected. Never been suggested this wasn't correctly decided. In fact, it's referred to in Kawaja, another case Mr. Belloc reminded me in which he appeared. Yes, I think Lord Brack.
You've got vindicatory damages of £150.
Yes. The next case is a decision of the Court of Appeal. Lord Justice Clark, as he then was, volume 10, tab 105, and I'm afraid this will be familiar to those members of the court who heard the SK case. It's 10.105. It's a case about a failure to conduct detention reviews as required by Section 40 of PACE. And it's interesting for our purposes because a causation defence is raised and squarely rejected by Lord Justice Clark. The judgment begins over the page at 663, the foot of the page. You'll see at 664, the plaintiff was arrested at 10:50 p.m. He was taken to Northwich Police Station, where his detention was authorised at 11:25 p.m. He was escorted to Macclesfield Police Station, and that was the problem in the case, because he was taken there, he arrived there at 1:45, and the police officers there thought that time began to run from his arrival at Macclesfield rather than, in fact, the true position, which was his arrival at Northwich. So the letter C, at 7:45 a.m., the police inspector conducted a case review. In fact, that should have been undertaken at 5:25 p.m. That's 6 hours after arrival at the police station. Then the act is set out at 664G. We don't need to examine that in the way that we did in the SK case because the issue is different here. Obviously, the question of review and the importance of review was key. At 666, letter C, the causation issue is raised. Counsel for the defendant, Mr. Benson, submits that the plaintiff could only prove false imprisonment if he could show that if the review had been carried out at the appropriate time, he would have been released. It is common ground, it is in any event the case, that the plaintiff could not show that he would have been released, because there is no doubt that if a review had been undertaken at 5:25 a.m, his continued detention would have been authorised for the same reasons as it was subsequently authorised at 7:45 a.m. No doubt why what happened, there'd been an honest mistake. And then over the page, at 667b, Mr. Benson submits that so long as circumstances existed which were or would be sufficient to justify continued detention, the plaintiff could not be fairly said to be detained without lawful excuse. I'm, however, unable to accept that submission. From 5:25 a.m, the plaintiff was not being detained in accordance with the Act because no review was carried out. As I see it, it is nothing to the point to say that the detention would have been lawful if a review had been carried out, or that there were grounds which would have justified continued detention. Part 4 exists in order to ensure that members of the public are not detained save in certain defined circumstances. In all other circumstances, every member of the public is entitled to his or her liberty. And then there's a discussion of the period of time for which it could be said detention was unlawful, which needn't concern us, and damages are looked at 668b. Unless your lordships would like me to, I wasn't going to deal with this now.
No.
So a flat rejection of the causation defence. My lords, we also rely on TF, a mental health case. I'm not going to take you to it. I'll just give you the reference, which is volume 18, tab 178. In our case, we summarise it at paragraph 70. Now, what the Secretary of State says about these cases, and there's one more very important case I'm going to take you to, which is the Langley case, where my Lord Sir John Dyson gave leading judgment. But what the Secretary of State says at paragraph 8.22 of her case is that these are all no power cases. No jurisdiction cases, pre and his minute. And therefore, they don't present any difficulty for the causation solution. So, Krishnashinsky, condition precedent. Roberts, express condition precedent. TF, no power. Kuchenmeister, no power. But Langley, let's see what she says about that. Langley was a similar case of the constable having no power to do what he did. As an emergency protection order was enforced, it was in effect, and please ask you to underscore, in effect, mandatory to use those procedures in the circumstances. If we can go to Langley, we will see that it was not a no-power case at all. It was a case about wrongful exercise of power. Langley is at volume 15, tab 148.
There is a certain difference between the authorities that you're giving us and the numbers given in Mr. Bellow's argument. Presumably he's got it wrong. I mean, they've changed, have they?
Sorry?
Well, I was just looking at page 48 of his pretty case. I mean, the various authorities we've been looking at are slightly different in number. Langley, he puts down as 153. You tell us it's 148.
I'm so sorry, I don't know how that's occurred. It is 148.
My Lord, you were working off an order list about exactly what was in the order list, the tax union was compiled. They were
It's very regrettable.
Can you just give us the volume number again, please?
15,
Thank you.
148, my lord. So the issue was whether the police were entitled to remove a child under their removal power in section 46 of the Children Act in circumstances where an emergency protection order had been obtained under section 44. And you'll see, my lords, if from page 378H, the whole the beginning of my lord's judgment, the judge held, as a matter of statutory interpretation, that once an EPO had been granted, and as long as it remained in force, the police cannot remove a child to suitable accommodation under section 46. That was a finding below with which my lord was to disagree. And the facts are set out. The family, except Callum, who was the boy in issue, when he was removed, were profoundly deaf. The father suffered from Usher syndrome, night blindness. A problem was that he persisted in driving a car with his children as passengers. You see that at 379B. That was the background. He'd driven his children to Derby for them to attend a school there. The local authority applied for an EPO. That was granted. That's page 3, letter H. It was granted. By that time, over the page, the two children had been left in Derby, and Callum had been driven back by his parents to Liverpool. The EPO was sought to be executed. At paragraph 10, in the evening, police officers attended the home, handed the parents a copy of the EPO. Callum was awakened and taken from his bed. Social services were called. They confirmed they wanted Callum to be taken into care. The officer removed Callum to foster parents. His main concern was that Callum mightn't be safe if he remained at home. He noticed that the bonnet of the car had been warm. Then we can go over the page to section where the statute is set out. Section 44 is set out at paragraph 13. Section 46 is at 14. What my lord held was that the former was the preferable route. It gave the child far more protection, and it had primacy but not exclusivity. The judge below had held that section 44 had exclusivity, so there was no power under 46. My lord held that it had primacy, so this was not a jurisdiction case, narrow jurisdiction case at all, and Mr. Beloff, I respectfully submit, doesn't have an answer to it, insofar as his answer is an answer at all in respect of the narrow jurisdiction cases. My lord's judgment begins at 18, at page 382G. My lord recites the judge's finding below. Once the EPO has been granted, the authority for the police to attend must be a warrant under 48.9. That's what implements the EPO. And then my lord looks at the relationship between the two powers at 384F, paragraph 24 onwards. My lord finds at 385H that where an EPO is enforced, it's almost always preferable for the removal of children to be effected by professional social workers executing the EPO rather than police officers under section 46. And then at the top of the page, paragraph 30, there is nothing in the language of the Act which compels the conclusion that section 46 cannot be invoked where an EPO is in force. And to similar effect, the final sentence of paragraph 32, section 46 can be exercised even when an EPO is in force. And then here, paragraph 33, 4 lines down, it is trite law that discretionary statutory powers must be exercised to promote the policy and objectives of the Act. Padfield. So this is a exercise case, exercise of powers, not an existence of powers case. And over the page, my Lord contrasts the two regimes, 34, the section 44 regime, paragraph 30, did I say section? I meant paragraph 34, the section 44 regime, paragraph 35, the section 46 regime. That is quite different. The court isn't involved. A police constable is authorised to remove a child, etc. And then the critical ruling under 36 and 37, I'd hold that where a police officer knows an EPA is in force, he should not exercise the power of removing a child under section 46 unless there are compelling reasons to do so, etc. And the justification for that is set out. 37, there are a number of important differences. The court can give directions with respect to contact, etc. Valuable power not available to the police. Secondly, an EPO gives parental responsibility. Thirdly, the child can be kept in police custody for more than 72 hours, in contrast with an EPO. So the statutory scheme accords primacy, not exclusivity, primacy, to section 44. It's a sophisticated and complete process. And again, my Lord reaffirms that at paragraph 40. 43 over the page, was the removal of Callum unlawful? My Lord assumes that section 46 was invoked by the officer. And over the page at 389, Sergeant Jones had jurisdiction to remove Callum.
Which paragraph?
44.
Yep.
Top of the page.
Yep.
The sergeant had jurisdiction to remove Callum. Were there compelling reasons for exercising this power? In my judgment, no. And then at 45, had the sergeant telephoned the EDT, that's the emergency team, he should have asked them to come to the Langleys' home to execute the EPO. A few lines down, when an officer is aware it's enforced, this is a wrong approach. In the first instance, he should have asked the EDT whether they could execute the EPO. If the response was they couldn't execute it, then he might well have been justified. And then right at the end of letter G, Sergeant Jones was in error in failing to ask himself, that doesn't look very much like pre-anismic jurisdiction territory, in failing to ask himself whether there were compelling reasons why he should invoke section 46 rather than leave it to the council to execute the EPO. So that is a classic process error. And there is liability in false imprisonment and assault found at paragraph 48. Sorry, Michael. Paragraph 48. I do not understand Mr. Wells to submit that if the removal of Callum was unlawful, the judge was wrong to find that the Chief Constable was liable to Callum in assault and false imprisonment. If that's intended to elevate the judge's reasoning over my Lord's treatment of the issue, then we'll wait to hear Mr. Beloff weave his customary magic. But my Lords, what's really interesting about this case is that the whole premise of the finding of illegality is that the child was going to be removed and detained under a different power. That's the very basis for the finding. If a causation defence would run, this case wouldn't have got off the ground. My Lord observed over the page, dealing with the Article 8 issue, interestingly, in the context of Article 8, not in the context of false imprisonment, my Lord observed, at the bottom of the page, it is tempting, if the removal of Kadian to the care of the foster parents could lawfully have been effected by the Council's EDT executing the EPO, then it is tempting to characterise this removal by Sergeant Jones as a mere technical error of law. In my view, it was more than a mere technical error. It is for the good reason that Parliament has accorded primacy to Section 44. The police undoubtedly have a role to play in protecting children, etc. And then, referring to Lord Hoffman's observation in the Wainwright case about negligent interference with Article 8, my Lord says, even where the removal was made by an officer who acted in good faith in circumstances which justified the removal of the child by the Council of Social Workers to the very foster carers into whose care he removed them.
I'm sorry, which paragraph is that?
Sorry, my Lord, it's at 391 B to C,
Thank you.
the bottom of 52.
Yes.
And the observation about damages, which I think I referred earlier when my Lord raised the issue of the Murray case, Lord Griffiths and Murray, is at 396 B to C, where my Lord found it difficult to see on what basis an award of substantial damages could probably be made. But there was barely an argument about liability.
And there was no argument at all about the tort of false imprisonment being committed if the removal was unlawful in public law terms, which is the issue we're really concerned with.
Well, my Lord, that was the only way the tort could have been committed, because the child was removed.
But it just went by concession. There's no argument advanced.
No, I accept that the causation argument wasn't advanced, yes.
And depending on which power was used to remove the child depended what the consequences were. I mean, as I understand it, that's why they thought it should have been...
No, not the end point. The process was different. The Section 44 power gave the child more protection than the Section 46 power. But at the end of the day, the child was going to be removed into foster care.
I mean, is the reason why police shouldn't be exercising their powers is because it's very much more frightening and alarming if a police constable comes and takes a child away than if social workers do.
Yes,
is that the thinking?
My Lord set out the advantages in fine detail. Correct me if I'm wrong, but they included the fact that the court is involved, parental responsibility shifts, and it has a greater duration.
And it's the professional skills
Indeed.
of the social worker.
Indeed, of course.
In very sensitive circumstances.
Of course. So there were process protections, my Lord.
Yeah.
But the fundamental point is that the issue wasn't removal and confinement versus liberty. The issue was removal and confinement versus removal and confinement. But which process do you go down? And you get it wrong, you're liable in tort. Well, I accept, my Lord, the President's point that the contrary argument wasn't put. But the contrary argument, we say, is completely unprincipled and would have been rejected if I continued to say that. Now, so we say, with respect, Langley is a long way from the way my learned friend deals with it. It's clearly not a no-power case. Now, my lords, can I turn to the cases which we say have been misunderstood in this area, the area of unlawful detention in the immigration field. And we deal with them in our case, in our printed case, at paragraph 113 onwards, at page 43. The first case is the Sardi case, and that is at volume 11, tab 119. And here, my lords no doubt be fairly familiar with the case. So the issue in Sardi, which we have first of all in the Court of Appeal and before Mr. Justice Collins at 119, the issue in the case was whether a policy to detain certain categories of asylum seekers under Schedule 2 powers, whose claims could be processed quickly, who were not absconding risks, was lawful. Oakington detention. And the House of Lords and the Court of Appeal held it was, overruling Mr. Justice Collins on the Article 5 issue. Mr. Justice Collins had also considered that the Home Office has used erroneous standard forms not reflecting the new policy, and true reasons hadn't been given. He indicated at paragraph 16 of his judgment that the use of inappropriate forms may not have been wholly accurate, didn't affect the lawfulness of the detention, expressed himself in strong language, but made the point at at letter F on the page, that he didn't need to go into the matter further since counsel hadn't sought to argue that the muddle about reasons rendered detention unlawful. And Lord Sling in the House of Lords agreed with this conclusion. House of Lords judgment is in the next tab, the final page of the next tab, at paragraph 48. It is agreed that the forms weren't appropriate. It's, to say the least, unfortunate. And he agreed with Mr. Justice Collins that the failure to give the right reasons didn't, in the end, affect the legality of the detention. Now, obviously there seems to be an inconsistency there between Sardi and Christian Liczynski, which my Lord do not need to decide. We make our submissions about the inconsistency at page 45 of our printed case. The question may arise one day for decision, but you don't need to decide it, and I won't make submissions on it unless I'm asked to. I made short submissions on it in the SK case, if my Lord, in response to a question from my Lord would hope.
But the point wasn't argued either.
Not at all, even by the highly eminent counsel for Sidney Kentridge appearing in the House of Lords for the claimant. And we've got the printed case. This wasn't reported in the law report, so we took the liberty of putting the printed case before my Lords. And it's clear it wasn't argued. But what we say is, first of all, that neither Mr. Justice Collins nor Lord Slynn purported to establish any novel causation defence. There was no dispute as to what the real reasons for detention were. The case was Oakington suitable. That was the real reason. And those real reasons were lawful, as the Court of Appeal, House of Lords, and indeed Grand Chamber were to find. But the position here is the reverse of Sardi, because the unpublished policy was intended to be the real reason for detention, and it is common ground that that intended real reason was unlawful. So the courts in Sardi weren't required to be drawn into a hypothesis about what would have happened had the law been complied with. It had been, in reality. And that's not the position here. So the law hasn't been complied with. And we say that far from adopting a causation defence, the courts proceeded on the basis that there wasn't such a thing. Well, I accept, again, my Lord's point that it wasn't argued in that way. But we say that this is clear from my Lord, the President's judgment in the Court of Appeal. If you could flick back to 118, at paragraphs 15 to 17, and so this is at page 382 of the report. You'll have two 15s because Mr. Justice Collins is at the beginning. So it's page 382, the report. At the bottom of the paragraph.
Sorry, are we in tab 118, did you say?
119.
119.
Well, we're back to 119, sorry, yes.
Sorry, my Lord.
Yes. And we're paragraph,
Paragraph 15, my Lord, at the bottom, it's at page 382, which will be,
yes,
you may have two paragraphs, which is just at the
yes,
beginning
yes.
of the report. Paragraph 15, my Lord says, we are not aware that it has ever been the policy of the Secretary of State that applicants for leave to enter should be detained pending the decision of their applications, however long that might take. A more liberal policy has been adopted. If the basis upon which immigration officers are detaining asylum seekers at Oakington is in conflict with this policy, then under established principles of public law, they are acting unlawfully. And then at 17, my Lord says, describing the White Paper 1998 Presumption of Liberty, the policy was amended, I think, in 2000. But my Lord says this at 17. Had this policy persisted, the claimants would have had an unanswerable claim. Home Office policy, however, changed in March 2000. So there's no suggestion there with respect that the Court of Appeal were adopting a causation defence. If illegality had been established, they would have had an unanswerable claim. Where, as I've already said, where Sardi departed from orthodox principles of tort law is in finding that the communications of false reasons to the detainees didn't render their detention unlawful. Now, we say it's possibly arguable that the reasons for detention were plain from context. That we accept can't be squared with the Grand Chamber's finding later on under 5.2. But for our purposes at the moment, all we need to say with respect is that this is not support for a causation analysis. The court did no such thing. No court did anything like that. The next case, my lords, I'd like to take you to is Nadaraja, which is at volume 14, at tab 137. Because of one particular paragraph in this judgment, paragraph 69, this case is often cited as endorsing or confirming a causation test. We say that on analysis, it did no such thing. The key paragraphs are 68, 69, and in particular 72. And they very clearly indicate that no causation defence or test was being applied. In this case, the published policy of the Secretary of State was that if legal proceedings were initiated, removal wouldn't be treated as being imminent if it otherwise was. And that had ramifications for detention. And an initiation of proceedings would contraindicate detention. But the Secretary of State also had an unpublished policy that if you communicated information that proceedings were about to be started, that would be disregarded irrespective of the credibility of that information. That was unpublished. And Nadaraja was detained by reference to the unpublished policy. And the critical finding in N's case is at 68, at page 161. And halfway down the paragraph, my Lord Phillips says, those acting for N could reasonably expect, having regard to those aspects of the policy that have been made public, that N would not be detained on the ground that his removal was imminent. The only basis upon which the Immigration Service could treat his removal as imminent was by applying that aspect of the Secretary of State's policy which had not been made public, namely that no regard would be paid to an intimation that judicial review proceedings would be instituted. The Secretary of State can't rely upon this aspect of his policy as rendering lawful that which, on the face of it, was at odds with his policy as made public. For these reasons, we conclude that that the judge below was correct to hold that the detention of N was unlawful. Now, if one stops there, that's readily understandable. What has been alighted upon by the Secretary of State is what follows in that paragraph, and that observation following in that paragraph has been elevated as being the test. Because my Lord says that Mr. Justice Stanley Burns, as then was, remarked that there was substance in counsel's submission that N's detention was a penalty for his solicitor's failure to initiate judicial review proceedings before the interview at which he was detained. The evidence suggests that had she been aware of the unpublished aspect of the policy, she would have instituted proceedings, and suffered because his solicitor couldn't foresee the consequences of her conduct. The detention didn't satisfy Article 5.1f. Now, we say that everything in that paragraph after the first sentence is simply an additional reason for finding illegality. The court had already found that reliance upon an unpublished policy at odds with a published policy was not, meant that detention couldn't be said to be lawful. And what we would respectfully submit the court were getting at was the idea that publication serves the intrinsically important function, the intrinsically desirable function of promoting transparency in the law. And what the court went on to address is what might be called the instrumentally desirable function of letting people know the consequences of their actions. But, my lords, that analysis is compellingly clear in the case of the co-claimant. Because he had been detained for two reasons. First, pursuant to the same unpublished policy, and second, because there was an unpublished policy permitting detention in order to get travel documentation. But the critical point in A's case is that there's nothing he could have done had the policy been made public. He couldn't have, unlike N, who could have brought judicial review proceedings, A couldn't have initiated his appeal because the decision hadn't been made. And detention for the purposes of documentation was held to be lawful had the policy been published. So we say that it was plain there wasn't any penalty in his case. The court held that his case was even stronger at paragraph 70. His case was even stronger than N's. And at 72, the court concluded that had the Secretary of State included in his policy as a reason for detention to facilitate documentation needed for removal, we do not believe that any objection could have been made under Article 5. Equally, had he published his policy to disregard any intimation that proceedings would be initiated for the purposes of deciding when removal is imminent, he would have been in a position lawfully to detain A for that reason and the additional reason that detention was necessary for documentation purposes. In the event, the detention was unlawful for the same reason that N's detention was unlawful. Precisely so, we say. It was unlawful for the reason set out at paragraph 68 and the first sentence of 69, as in N's case. It was at odds with the Secretary of State's policy as made public.
So, I mean, I don't find this case another out of that easy, but surely both of them. I mean, the published policy is, we're going to release you if removal is not imminent. And in both cases, actually, removal was not imminent because they were going to exercise their respective rights, one to challenge, the other to appeal. And therefore, I mean, they simply were not given the advantage. I mean, the fact that it was a secret or undisclosed wrinkle on the policy that they weren't going to treat, an intimated notice of appeal or legal challenge as, so to speak, worth anything at all. I mean, that's almost by the way.
You could, my lord, construe Nadaraja in that way. It would require some reading down of paragraph 69, but I accept of the first words, of the first three words, for these reasons. Obviously, one doesn't read this as a statute. But you could, on the facts, I accept that you could construe N's case as being decided in that way. You can't construe A's case as being decided in that way. And perhaps the easiest way to take it is from the head note at 139, because that tells you what the chronology is. And the chronology indicates that had the decision been made public, had the policy been made public, A couldn't have done anything at all.
No, I'm sorry, you misunderstand me. I'm not suggesting I'm not suggesting it goes to causation. What I'm suggesting is that there is a published policy, release if not imminent. Here, it wasn't imminent, and they weren't entitled, by reference to some unpublished policy, to treat it as if it was imminent.
But imagine the scenario, my lord, where they had published the policy. In A's case, had they published the policy, they would be entitled to say it's not, it's imminent. Had they published it, they could have discounted intimations, they could have detained him for travel documentation, they could have said removal is imminent, and they could have detained him.
Yeah, I'm sorry, yes, I mean, that goes to the second aspect of A. I was looking at the aspect that they had in common. And they,
In fact, they don't have anything in common, because although...
I don't want to take, I don't want to take everybody's time up. It's
No,
just
sorry,
that I have to-
if I can just be very quick. Factually, they didn't have anything in common, because there was a 2-day time lag in Nadaraja's case between the 25th and 27th of February, in which he could have brought judicial review. You get that from the head note. There's nothing that A could have done. A's solicitors are saying that an appeal to an adjudicator would be lodged when he was detained, would be in the future. The decision to refuse his claim hadn't been made. You publish the policy for the Secretary of State, A is detained. He could have brought his appeal. Anyway, my lords, the next case I'd like to take you to is...
Where do you comment on this at paragraph 115 in your case? Is that right? Just trying to pick it
yes,
up in the narrative. I think that's right. Yes.
The critical thing is perhaps at page 47, letter E to F. That passage is the critical passage for us.
Right.
If we're right on that,
Yes.
and we respectfully submit that we are, then causation just doesn't begin to run in A's case.
I mean, I hope you're right. I wasn't putting to causation ran. It was a different point. I'm sorry, but I really don't want to take everybody's time.
I'm sorry if I've not assisted my lord.
But in this court, it's the question of principle, not a linguistic analysis of the decision of the court.
Oh, of course, but my lord, Nadaraja has been cited. It was cited in the courts below as underscoring a causation test, and I am meeting that challenge, as it were. It's what Mr. Justice Davis relied upon. It's what Mr. Tam argued before Mr. Justice Davis, and also before the Court of Appeal. It is, we say, misunderstood as a causation authority, and we respectfully submit it's no such thing. But of course, for my lords, it's a question of principle, of course. My lords, can I take you now to D very quickly, which is the case at volume 14, 141, the same tower. And the passage that is cited is at 109. This was a strikeout application, an appeal, from a successful strikeout application by the Secretary of State. I'm given a note, my lords, which I'm going to read out by Mr. Hickman. It is relevant to the question of principle the Secretary of State has not found a single authority for a causation defence of false imprisonment in hundreds of years, or in this or any other jurisdiction. And we respectfully support that. So D, my lords, is at 141, the passage. So I've just lost my note. sorry, it's at 1110.
1110.
Yes,
110.
page 1033. And this was a case of Schedule 2 detention. The claimants were detained at Oakington again. They brought a claim in false imprisonment. The Secretary of State applied to strike it out on various grounds, Home Office rather, I should say, including on grounds of abuse of process, procedural exclusivity point. And it was in the context of Mr. Catchpole's submissions on that point that Lord Justice Brooke made the observations that have again been seen as underscoring a causation test. So 1033, Mr. Catchpole submitted we should bear in mind the consideration that when administrative court quashes a decision of an immigration officer on the grounds of public law error, there will be nothing to stop him making the same decision, this time by a lawful route. It appears to me that the answer to this objection lies in the field of causation. In Nadaraja's case, the court held that immigration officers hadn't been tainted by their failure to disclose the policy on which they'd relied. The applicant's lawyers would have ensured that legal proceedings would have, in fact, initiated and not merely threatened. We say that's, with respect, a misreading of Nadaraja. In Sardi's case, on the other hand, Lord Stilton observed the failure to give the right reasons for detention, although procedurally inept, didn't affect the legality of their detention. So again, we say that's, with respect, a misreading. And what is particularly interesting about that is the passage which follows, because in the passage which follows, Lord Justice Brooke is very clear in rejecting the distinction between errors which are actionable in administrative law, invalidating a decision, and which don't, i.e. pre-anisminic and post-anisminic jurisdictional errors. The judge says at letter D, if a court judges that in making his decision to detain, an immigration officer fails to take into account matters of material significance, vis-à-vis that he's overlooked relevant features of policy or paid no regard to the UN Convention on the Rights of the Child, then he will have strayed outside his wide-ranging powers. As a result, he will have had no power to authorise the detention in question. This is what the doctrine of ultra vires is all about. So in that passage, you have an orthodox application of ultra vires principles. Now, my lords, I'm not going to take you to the two other authorities. They're dealt with in our case. It's a first instance decision of Mr. Justice Davis in a case called D&K. We deal with it at paragraph 124. The reference is volume 16, tab 153. And we also won't take you to the SK case, which is, of course, under appeal to this court, because we respectfully say that Lord Justice Laws simply followed earlier authorities rather than adding analysis of his own, if I could put it in that way. I hope that's a fair description of SK. So, my lords, I want to deal with wider objections to the causation test as applied by the Court of Appeal below. And we deal with this at paragraphs 103 to 106 of our case. And the first objection is a reductio, 104, which is that on the causation test, you don't even need a decision to detain. You can simply construct one on a hypothesis. And that means that justification for lawful detention occurs by way of hypothesis rather than authority. Let's say someone gets lost in the system. They finish their criminal sentence and they just detained in the prisoner state. My client, WL, was detained in the prisoner state for, I think, approximately 7 months, from January 06 to Jan 07. Let's say nobody turns their mind at all to that person's detention, but it said, after the event, that here you had a very serious criminal, and he wouldn't have had a hope in hell of being released. So no decision at all.
So nobody began to exercise Schedule 3 powers at all.
Let's say, I'm not saying it happened in my case, but I must be able to test the causation defence by reference to these sorts of facts. You don't even need a decision. Mr. Tam would argue, well, he would be detained anyway. It doesn't stop there, because the hypothesis doesn't even need to be that of the detainer. Why can't the Secretary of State argue that if she hadn't detained the individual, Her Majesty's Revenue and Customs would have done? Why couldn't the police in Langley argue that the child would have been detained by the father, let us say, or by somebody else? If the hypothesis needs to be that of the defendant, then why restrict it to the same statutory power? Let us say that the Secretary of State unlawfully detains an immigrant under the Immigration Act, unlawfully, but then argues that, well, this was a mentally unwell man and he could have been detained under Mental Health Act powers. How does one keep the hypothesis within bounds? How does one stop it running riot? What's the principal distinction between the same defendant, the need for a decision, the same statute? If you're allowed to bring into the equation counterfactual situations, then anything should come in. And there has to be some reason why it is limited to the same defendant under the same power. But even then, how do you explain the no decision case? This is to replace detention under colour of authority with detention under colour of a fairy tale. We also say, my lords, my lady, that the causation defence is inconsistent with the court's proper role on a judicial review of Immigration Act detention. The role remains one of review And so the basic principle that the court should be very wary of being drawn into the forbidden area of speculating how the authority, the public authority, might or would have acted, remains sound. It is the case that the court decides the Hardiel Singh question for itself, another one of Mr. Belloff's victories in the Tan T. Lam case, which is then applied by the Court of Appeal here. But that doesn't mean that the court supplants the Secretary of State as the statutorily assigned decision maker. Nor does it mean that outcome is the only thing that matters, and that process errors can be ignored or justified after the event. No difference. Can I please take you to the A. Somalia case, which collects the Tanti Lam dicta and establishes the test that is applied in these cases under Hardiel Singh. I'll just do it very quickly if I may. 17168. This is a case with troubling facts. It's of a detainee who'd been convicted of raping and indecently assaulting a 13-year-old Somali girl. We'll come back to this in WL1 when we look at the Hardiel Singh issues. The relevant passage for present purposes is at paragraphs 60 in the judgment of Lord Justice Toulson, where the role of the court is looked at. 61, Mr. Giffen advanced a subtle argument in support of a review jurisdiction based on certain passages in Tantilam and Kadian. And 62, I intend no disrespect by not going to the refinement of the argument, but dealing with the matter on a broader basis. Where the court is concerned with legality of administrative detention, I do not consider that the scope of its responsibility should be determined by or involve subtle distinctions. It must be for the court to determine the legal boundaries of administrative detention. There may be incidental questions of fact, which the court may recognise that the Home Secretary is better placed to decide than itself. The court will no doubt take such account of the Home Secretary's views as may seem proper. Ultimately, however, it must be for the court to decide what is the scope of the power of detention and whether it was lawfully exercised, as two questions being often inextricably interlinked. My judgment, that is the responsibility of the court at common law and doesn't depend on the Human Rights Act. And then 67, Lord Justice Longmore agrees with Lord Justice Toulson. Lord Justice Keane is at 70. Middle of the paragraph, paragraph 70, it's been submitted on behalf of the Secretary of State that the role of the court is simply to review his exercise of power on the usual principles applicable in judicial review, albeit that the court scrutiny would be more intensive than usual. Mr. Giffen QC's content of the court should not itself determine whether the period of detention exceeded that which was reasonable in circumstances, but should ask itself whether it was open to Secretary of State to regard detention as appropriate. 71, it is to my mind a remarkable proposition that the courts should have only a limited role where the liberty of the individual is being curtailed by administrative detention. Classically, the courts of this country have intervened by means of habeas corpus and other remedies to ensure that detention of a person is lawful, and where such detention is only lawful when it endures for a reasonable period, it must be for the court itself to determine whether such a reasonable period has been exceeded. Then he cites the decision at first instance of Youssef and Tanti Lam at paragraph 72. And then at the top of the facing page, if the Secretary of State were to be entitled to determine what weight should be attached to, say, the risk of the detainee absconding if released, as compared to the weight to be attached to other factors, and so to decide whether the length of detention was reasonable, with the court only intervening if his decision was not one properly open to him, the erosion of the protection of human liberty referred to by Lord Brown-Wilkinson would be very substantial indeed. The erosion of the protection of human liberty. We've already got, my lords, the passage in Christian Leszczynski where Lord Simmons talks about the need for due process of law to be complied with. Now, this case has been interpreted, quite wrongly, we respectfully submit, as a license for process errors to be ignored on judicial review of executive detention under the Immigration Act.
By this case, you mean our case?
A Somalia.
Oh, sorry, A, right.
Because what's said is that the court's the decision taker. And it doesn't matter if you've committed numerous process errors along the way. Because at the end of the day, the court can decide for itself whether detention is lawful or not. We submit that that is a profound misreading of this authority, inconsistent with the common law, inconsistent with conventional jurisprudence, and something which the court should clarify. This case was intended to enhance the protection available to a detainee on judicial review, not to diminish it. Ignoring process errors diminishes protection. What about the people who don't get to court? I'll come on to that in a moment. Then there's the deference point, my lord, because this case does not convert review into appeal, and as paragraph 62 of Lord Justice Toulson's judgment indicates, there may be incidental questions of fact which the court may recognise that the Home Secretary is better placed to decide than itself. And that underscores the need for those questions to be properly determined by the Secretary of State, who has properly directed herself. Otherwise, the court will be giving weight to defective assessments. You have an example of the Secretary of State claiming deference in this case, in WL, at Appendix Part 1B, page 592. If my lord wants to turn that up, I'll go to it.
Page what?
1B 592, my lord. And it's at subparagraph 5 of paragraph 58, and this is the skeleton argument of Mr. Dunlop before Mr. Justice Collins at first instance. And what Mr. Dunlop says...
So, page 512, did you say?
592.
592, sorry. And it is said that the claimant poses a high risk of absconding. But a subparagraph 5, Mr. Dunlop cites the Cezek case for the proposition that the court should give weight to the defendant's view of the risk of absconding because of the defendant's experience in that area. So he's claiming deference.
Well, what's wrong with that?
There's nothing wrong with it. What's wrong with it, my lord, is if that is then ignored, I'm sorry I haven't been clear. The point of my submissions here is to make it clear that the role of the court, and it may be something that the court finds difficult to understand because it's self-evident to the court. The role of the court remains one of review. Process continues to matter. Outcome isn't the only thing that's relevant. But that is how this case has been interpreted. And you get an example of that in the Annan
Sorry,
case.
we're still on East Somalia now, are we?
Yes, Somalia. I'm only talking about Somalia, my lord. Somalia has been interpreted to mean that you can ignore process errors and focus exclusively on outcome. And an example of that, I won't take you to it, is a very recent decision of the Court of Appeal in a case called Annan, which is the final domestic authority in your bundles. And it is at 22-224, volume 22, tab 224.
Where do you refer to it in your printed case?
We don't. It post-dated our printed case. The relevant paragraph, you see, my lord, it came out on the 19th of October.
Yes, yes.
And the relevant passage in the judgment of Lady Justice Black begins at 73, and at 77 she takes Somalia as binding authority. The court must assume the role of primary decision maker rather than simply reviewing. And
What was the process error you say was in that case?
sorry?
What was the process error that the court didn't think mattered because of the approach of the court acting as primary decision maker?
In relation to mental health policy. The relevant paragraph is 32, I'm grateful. 32, which is the judgment at first instance.
Where is the error, if there is one, in Lady Justice Black's judgment occur? She seems to go back to 77 to say what she sees Somalia as being binding authority for.
My lord,
Very difficult.
I beg your pardon, I'm just asking where do we find the error in Lady Justice Black's approach?
Yeah.
it is, my lord, if you look at 77,
Yes.
at about 7 lines up, that the court itself decides on the legality of the detention, attaching appropriate weight in its deliberation to matters such as government policies, risk assessments, so forth.
What about,
I think sorry.
isn't the sentence about 8 lines down into the paragraph helpful? One beginning, I'm inclined to agree.
Whereas the first
My lord, yes. I'm sorry, I've bowled you a dud.
Well, it might be. You're,
Maybe some quite useful
May not
Get your own
may
wiki,
not
but that's not.
may not agree. There is another example of the problem I'm talking about. I'm sorry if that doesn't exemplify it. You have it in Mr. Justice Collins.
This is quite helpful. This paragraph 77
Yes.
of Lady Justice Black's judgment appears to be very
It
much
is.
in your favour.
It is.
Apart from the fact that she's having to wrestle with SK in the Court of Appeal.
Indeed, it is. My lord, my lady, can I review my attempt to give you an example of what we say the problem has been, and simply say to you that it is important that the court retains its review function and its enhanced function on review, and what that an enhanced function of deciding reasonableness, and the consequence that that has is that the basic principle that it is inappropriate for the Court on Judicial Review to be drawn into areas of speculating about how the decision maker would have taken his decision. See, the Tesco Stores case still holds good. And the importance, my lords, my lady, of the executive lawfully directing itself is demonstrated, irrespective of what happens when it comes to court, is demonstrated by Bidd's case at 38 to 39, where Mr. Fordham says that there are dual safeguards, executive and judicial.
Sorry, 38, 39 of what?
Of Bidd's case.
Bidd's case, yes.
Where Mr. Fordham talks about ensuring a system which involves an effective system of protection by frontline decision makers on the ground. And that's important because there will be many people who won't get to court, for whom compliance at the administrative level with legal safeguards will be very important.
Basically, if you're locking somebody up, and your order on the face of it will effectively lock them up, unless and until somebody mounts a challenge before a court, surely you've got an obligation to do it right.
Well, my lady, that's what I'm saying. And you have the HL case. The HL case says precisely that in the context of mental health detention under Article 5, where the Strasbourg court says that the 5.1 and 5.4 protections are cumulative and distinctive protections. And it says that at paragraph 121 of HL. You have HL. That was the Bournemouth case in the domestic courts, the necessity case, where the autistic patient who was unable to consent or object to medical treatment was transferred to a behavioural unit as an informal patient on the basis of the doctrine of necessity. The case is at tab 243, which you'll find at volume 25. And the relevant passages are at 120 to 124. My lords, my lady, I'm sorry for that digression. Mr. Beloff puts a number of sacred cows up for slaughter before your lordships and ladyship. He says, first of all, that you shouldn't follow Holgate Mohammed. We say that is really a challenge to Anis Minnick, because all Lord Diplock was doing was applying the Anis Minnick principle to the context of false imprisonment. The issue in Holgate Mohammed was whether an exercise of discretion was ultra vires on Wednesbury principles, because the officer had taken into consideration an irrelevant matter. And it doesn't really take anything any further, we'd respectfully submit, to analyse in great detail the Holgate Mohammed case in the present context. Holgate Mohammed you have at 763, and the relevant passage it is at force 46C to D. That's the ultra vires principle. The application of it, I should say. I want to take you very quickly, if I may, to the Boddington case, because that deals conclusively with this. If I can just remind you of the Boddington case, that's at volume 10, tab 104. This is the famous case about a smoker who wanted to smoke on the London to Brighton train, and the issue was whether or not he could raise a challenge to the bylaws preventing him doing that by way of defence to a criminal charge. And if I can take you straight away to the speech of Lord Irvine at 152. And the reason this is important is because Mr. Beloff is also saying to you, you should restrict the notion of lawful authority to pre-Anis Minnick jurisdiction, to no authority cases, to bad faith cases, to improper purpose cases. And that's at his case 10.5 to 10.18. And at 152, Lord Irvine says, at letter E, categorisations of types of challenge assists in an ordinary exposition of the principles underlying our developing public law. They're not watertight compartments, because the grounds run together. The exercise of power for an improper purpose may involve taking irrelevant considerations into account, etc. So they run together. It's pragmatically awkward, to say the least, to have the sorts of restrictions which Mr. Beloff would urge upon you. At 158, letter D to F, where Bug is overruled. Bug was the divisional court case which had said you could raise questions of substantive invalidity by way of criminal defence, but not procedural invalidity. And that is overruled. The Anis Minnick decision established, contrary to previous thinking, that there might be an error of law within jurisdiction. There was a single category of errors of law, all of which rendered a decision ultra vires. No distinction is to be drawn between a patent or latent error of law. And then across the page, at letter E, 159, many types of challenge shading to each other may be made to the legality of bylaws or administrative act. Anis Minnick freed the law from a dependency on technical distinctions. And then at 164, this is the reference in Lord Brown Wilkinson to unscrambling. You can see how that would be an issue in a context where you're challenging legislation, subordinate legislation. That's the Percy and Hall case upon which Mr. Belloff also relies. Completely different to our context because Percy and Hall is, as my Lord Brown will recall, is a second actor case. So no intermingling of time and law, as my Lord Roger put it, in our case. And then, my Lords, at page 170, another pragmatic problem with the endeavour which Mr. Belloff has sought to embark upon. 170D, also a formidable difficulty of categorisation created by Bubbs' case. The distinction between substantive and procedural invalidity will often be impossible to draw. And in citing Mr. Fordham as a modern commentator, he has demonstrated, letter E, has demonstrated the correctness of the proposition that grounds of judicial review have blurred edges. I should have said this is Lord Steyn, I'm sorry. They tend to overlap. And then Page is cited at the bottom of 171, Lord Brown-Wilkinson, where Lord Steyn says, leaving aside the separate topic of judicial review of non-legal powers exercised by non-statutory bodies, I think the takeover panel, for example, they see no reason to depart from the orthodox view that ultra vires is a central principle of administrative law, and then Page, the fundamental principle, the courts will intervene, etc. And at the bottom of the quotation, if the decision-maker exercises powers outside his jurisdiction conferred in a manner which is procedurally irregular or is wensibly unreasonable, he is acting ultra vires and therefore unlawfully. This is the essential constitutional underpinning of the statute-based part of our administrative law. And then also a rejection of procedural exclusivity. While I'm here, I'll just give you a reference to that. At G, since O'Reilly and Macman, decisions of the House of Lords have made clear the primary focus of the rule of procedural exclusivity is situations in which an individual's sole aim was to challenge a public law act decision doesn't apply in a civil case where an individual seeks to establish private law rights, which can't be determined without an examination of the validity of a public law decision. And then over the page, 174, where the distinction is drawn in the Bug case between substantive and procedural invalidity, 174C. As formulated, I'm unable to accept this proposition. Let me pose two cases, one a breach of duty to consult, another a breach of a duty to give a hearing. In both cases, that establishes the ground of review. It's true that cases could occur where it might be right in regard to an established ground of judicial review to refuse a discretionary remedy. In that respect, absence of prejudice may be a relevant factor. See Regent Baldwin, and see the classic case of Cotton. That's the police case, where I think my Lord Brown was at the first instance.
Fat policeman, yeah.
Indeed, the obese policeman. As to denial of a remedy, as to why denial of a remedy as a matter of discretion in such a case should be a rarity. But that is altogether different from saying that prejudice is an element that the applicant must prove to establish a ground of review. The no difference test goes to remedy in public law, not the ground of review, unless Lord Steyn is also one of the people who are wrong. And I think everybody agrees with him other than Lord Irvine, who doesn't disagree with him. Since Lord Slynn agrees with Lord Steyn at E, and so forth. Lord Brown-Wilkinson 2 at 163H, and Lord Hoffman at 176E. Now, where does that lead us? My Lords, we've prepared a note which Mr. Belloff has seen on burden of proof, which I'm going to deal with very quickly if I may. I'm sorry to deluge you with yet more paper. It's a short 3-page note. And this is an extrapolation of, we say, is the ultra vires principle. 3 times in her case, the Secretary of State says that the burden is on the claimant in a claim for false imprisonment to establish that the discretion to detain was unlawfully exercised. We accept, my lords, my lady, that the burden is on us to show we were imprisoned, but then we say that where the executive officer has exercised the statutory power of discretion, the burden of proving lawful authority for that, statutory power of detention, I should say, the burden of proving lawful authority lies at all times on the public authority. It doesn't revert back to the claimant. What the Secretary seems to suggest, and he has, we accept that he has some support for it, that she had some support for it, seems to suggest that what she has to show is some sort of condition precedent or pre-anisminic jurisdictional authority for detention, with the burden then reverting to us to demonstrate that the exercise of the authority was flawed. And the support that Secretary gets from that is set out at paragraph 4 of this note. And the whole thing comes from Lord Diplock's comment in the Holgate Mohammed case. We've got the references there. I won't invite you to turn it up, but it's simply something that goes without argument, where he just says, Lord Diplock simply says, it will be for the claimant to establish the power was unlawfully exercised, without argument. And subsequent Court of Appeal authorities, which we've cited, have followed that. We say that approach is wrong as a matter of principle, for the reasons we've set out at paragraph 5. First of all, it is well established that the burden lies on the defendant to demonstrate lawful authority. Secondly, it's contrary to anisminic to draw distinctions between types of illegality. Thirdly, it's difficult to draw a distinction between excess and exercise of jurisdiction. And that is demonstrated by the Hardy-Alsing principles themselves, where in Tanti Lam, Lord Brown-Wilkinson considered them to be limits to the existence of the power, and in Kadian, the House of Lords held, my Lord Brown, that in fact they were limits to the exercise of it.
Mr. Hussain, I can see it's an important point, but does it arise on this appeal? I mean, is there anything about burden of proof in the judgments below which you're quarrelling with?
It goes, it's a very fair point if I may say so. It goes to the question of reliance, which I'm waiting to hear what Mr. Beloff says, because there's some suggestion that we can't show that the policies were applied to us. Now, if that's not an issue, then it's not a live point, but it is an important point, we say, point principle, but it may not arrive at a decision subject to what Mr. Beloff says. The fourth point is a practical point and speaks to the asymmetry of information that will be enjoyed by the detainee and the detainor. And that is vividly demonstrated in this case, where the agency knew it was acting unlawfully. My clients didn't. And that would have been the position for many people over a 2-year period. Now, we accept at paragraph 8 of our note that it would be appropriate to require the claimant to identify grounds which he contends vitiate the authority. The public authority isn't supposed to come to court with trying to meet everything under the sun that might possibly be said against it. It's for the claimant to identify grounds and aver those grounds. But once they are identified, the burden rests with the defendant, and if they require the submission of further evidence or material or argument, the defendant must produce that, absent which the inference will be drawn that the lawful authority was not exercised lawfully.
Is the position that once the Secretary of State has shown that the statutory conditions are fulfilled, the claimant has an evidential burden of suggesting something?
On our argument,
yes.
Yes. You've got to raise the issue. And if you don't, then it's assumed that the authority was lawfully exercised. Yes, this is exactly right, my lord. But it's an important point, and we say our position is the orthodox position. There shouldn't be a different rule simply because it's not a private individual who's detaining somebody, it's a public officer. Why should that be different? The executive is, of course, subject to the ordinary law. That is a cardinal organising principle of our law. So why should it be different? And if you look at the Holgate Mohammed case, you see that it was something we respectfully submit Lord Diplock really didn't give any focused attention to at all.
Well, I think Mr. Bellow says that likewise he didn't give any focused attention to the aspect of it on which you rely, because it was all obiter anyway.
Yes, but in a way, my lord, that doesn't matter because it's an application of Annis Minnick, and Annis Minnick isn't obiter, Boddington isn't obiter. My lord, there's an executive decision, and if you show public law grounds to challenge it, it disappears in law. That's all that's being said in Holgate Mohammed. There's no magic in Holgate Mohammed. It would have been astonishing if Holgate Mohammed had said, forget about Annis Minnick, if Lord Diplock had said, forget about what I've said a couple of years previously in Racal, National Federation, and O'Reilly and Macklin, forget about all that. When it comes to detention, not all errors of law render the decision a nullity. You've got to show pre-Annis Minnick error. That would be astonishing. And the idea that he was limiting himself to improper purpose and bad faith is, quite frankly, with great respect, absolutely untenable. Yes, that may have been what that case was about, but with respect, so what? The issue is one of principle. Now, my lords, Mr. Belloff also says that at paragraph 10.1 to 10.4 of his case, relying on the Lyons case, that a mandatory relevant consideration in public law ceases to be such if it made no difference on the facts of the case as judged after the event. And we say that is completely wrong. That's not how the law approaches mandatory relevant considerations. And in any event, the error in this case was something even more profound than that. The policy wasn't a mandatory relevant consideration. It was the only consideration. Now, we do say that any error of law has to be important. But that is not judged by what difference it makes. It's judged on the basis of the context and the statutory scheme. And the decision maker must take into account relevant and important matters whether or not they made a difference. And that follows from Tesco stores, we say. And the point is very clearly made, we submit, in the Hurst case. Now, Hurst you have, I would please like you to look at this very quickly. Hurst is at volume 39, 406.
Bit of excavation required to find.
Sorry, my lord, it's one of the latest.
40, isn't it? I mean,
Is it 40? Sorry.
I think it'll have to be 40, yes.
I'm so sorry, my note is wrong. It's 406. 40. You're absolutely right, I'm very sorry. So this was a case about whether the enhanced investigative duty under Article 2 was a relevant consideration for a coroner conducting an inquest into a death prior to the commencement of the Human Rights Act. And the House of Lords disagreed as to the status of the Article 2 consideration as a mandatory relevant consideration. I think my lady with Lord Mance was in the minority, but there was no disagreement about the effect of Article 2 if it was a mandatory consideration. And the relevant paragraphs are at 58 by Lord Brown and 79 Lord Mance. I should say at 57, my Lord Brown cites the well-known case of Cree NZ, and finds that the obligation is not a mandatory relevant consideration, not so obviously material. But importantly, Lord Mance says at 79 this, citing Justice Cook, there will be some matters so obviously material to a decision on a particular project that anything short of a direct consideration of them by the ministers would not be in accordance with the intention of the Act. This country's international obligations in relation to a death potentially involving state responsibility appear to me to merit equivalent recognition, at least as a relevant factor, even if the decision maker were in the event to regard them as outweighed by other considerations. And that's the point, that something is a mandatory relevant consideration, even though it may be outweighed by other considerations on the facts of the case. My Lord, those are my submissions on the common case. I don't know if you'd like to break at this point.
Yes, I think that would be convenient.
Could I just, before we depart, ask a question which has probably got nothing at all to do with the case, but I would like to know the answer.
Yes.
Because in the case of WL,
Yes.
the Secretary of State served deportation orders on his wife and his child
Yes.
as well. The child, as I understand it, is a UK citizen.
Yes.
So what was the basis of the Secretary of State's doing that? And what was the basis of the Secretary of State's serving a deportation order on the wife? And did the wife appeal? I know that WL has appealed unsuccessfully, but has the wife appealed? I merely ask these questions now. I don't expect you to answer them, but I would like to know the answers for a variety of reasons which may be apparent to some other members of the court.
I'll certainly give you that.
Thank you very much, Mr. President.
We'll adjourn.